In an unexpected, or I should say expected development, Idaho's new 6-week abortion ban is being taken to court 1 week after Governor Little signed Senate Bill 1309 into law. The reason it's being challenged? Exactly the reasons the governor expressed concerns over when he signed it, explaining it in detail in his letter. So what happens now? Joe Paris has those details.
1 week after being signed by Governor Little, Idaho's new 6-week abortion ban is being challenged in court.
It is purely and entirely designed to circumvent and dismiss our constitutional protections and right to abortion.
Rebecca Gibron is the interim CEO of Planned Parenthood Great Northwest. Planned Parenthood filed a petition in the Idaho Supreme Court early Wednesday, seeking a judgment to have the new law blocked before it goes into effect on April 22nd.
This bill is blatantly unconstitutional. Even Governor Little, who signed the bill into law, called the law unconstitutional and unwise in a letter to the legislature. Today, we are taking action to restore and protect Idahoans' right to abortion.
Governor Little and the Idaho Attorney General's office both expressed concerns about the legality of Senate Bill 1309, specifically the novel enforcement mechanism included in the law. It allows the father, grandparent, siblings, aunts, and uncles of a preborn child to each sue an abortion provider for a minimum of $20,000 in damages within 4 years of an abortion. Carrie Flaxman, Senior Director of Public Policy, Litigation, and Law with Planned Parenthood Federation of America, details the major constitutional issues they see with the law.
It violates the separation of powers limits in the Constitution by taking authority to enforce the law away from the executive, away from prosecutors. This is not the way laws are supposed to be enforced. It's not the way our system works. The Idaho Constitution precludes the legislature from doing that. It also violates equal protection rights because it completely changes the rules of litigation against abortion providers who can be subject to unlimited damages.
In debate at the State House, lawmakers who supported Senate Bill 1309 said they were working to protect life, specifically life that cannot defend itself.
If it is not alive, why does it require outside intervention to terminate it? And since it has its own DNA, its own circulatory system, and often of a different blood type, sex, or even race different from the mother's, it cannot logically be considered the body of the mother.
The petition to the court also includes Idaho family medicine physician Dr. Caitlin Gustafson. She details the results of the law for women seeking care in the future.
By passing Senate Bill 1309, Idaho politicians decided to make Idahoans' healthcare decisions for them. They are preventing physicians from providing patients with what is routine medical care. Instead of treating our patients, we'll be sending them to out-of-state providers.
Planned Parenthood and other advocacy groups are now working to raise funds and resources to help Idaho women get a safe abortion outside the state. But advocates say not everyone will get the help they need in the future because of this new law.
Not every patient will be able to travel. So this law is cruel. It is harmful. It will raise maternal mortality rates. We know that abortion bans do that. And particularly for marginalized communities in our state, it is absolutely government overreach in its finest form. These bans don't stop the need for abortion. They stop safe access to abortion.
All right, Joe, last week when we talked about this, we expected it was going to be in court, but we were thinking that it had to have basically a party that is affected by this. Obviously, that's not the case. And when will they see their day in court?
So the party in this case will now be the doctor that we just heard from and Planned Parenthood, and they're really going after the civil enforcement mechanism. To answer your question, though, Brian, they're hoping to get into an Idaho court, the Idaho Supreme Court specifically, before April 22nd. Again, that's 30 days out from Governor Little's signing of the Senate Bill 1308. So, 1309. Now, Brian, the idea is to get into court, but they don't have a date yet. They actually just filed the documents we were showing you on screen early this morning. So they also filed an idea to have an expedited hearing, and they want to have oral arguments in the Idaho Supreme Court soon. So if that happens, and we can expect that it likely will happen, that they'll get their day in court before April 22nd, it'll ultimately be up to a judge here in the state of Idaho to say yes or no. Now, to be very clear, the petition being brought forward, it just is for state. This has nothing to do with being brought up to a federal level or this trying to make the Supreme Court. This is about the state of Idaho and the civil enforcement mechanism. Now, there's a difference between what's going on in Idaho and Texas, because in Texas, the government has something called sovereign immunity, meaning that the exact same thing that we're seeing play out here in Idaho, it doesn't work exactly the same in Texas. So a lot of people are comparing the Idaho legislation to Texas, and there's good reason to, but the judicial, I guess, arrangements here are different. So we'll have to watch it play out.
All right. There's a lot to watch. All right. Thanks, Joe.